Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Alexa Hassel, Summer Legal Fellow at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So before we begin, first, we just continue to acknowledge that Mary Margaret Bush, our beloved former executive director, is now at the White House Religious Liberty Commission. And so my longtime founding co-host is no longer with us, and we've been starting to rotate guest hosts a little bit. So this week I'm excited. I'm going to welcome this week's guest host, Alexa Hassel. So Alexa is a rising third-year law student at Notre Dame, the executive editor of the Notre Dame Journal of Law, Ethics, and Public Policy, and a very talented emerging legal mind who I get to work with all summer. So it's been fun. Now I've been working with you long enough where I could confidently bring you on here. So glad to have you on. Thanks.
Thanks, Frank. Excited to be here.
Great. So this week I switched gears a couple hours ago before recording this because we're in that wonderful and unpredictable season for lawyers, especially lawyers who do the kind of work that we do, where the U.S. Supreme Court is releasing its opinions every week. So yesterday, now it'll be last week at the time you're listening to this, we had our script, we had our general issues that we wanted to cover, and then the Supreme Court on June 26th released its decision in Medina v. Planned Parenthood. And so I decided that I want to spend the bulk of my time this week discussing that, because I think the legal issues are very interesting. I think it's being a little bit mischaracterized in some of the media. And I just wanted to cover what actually happened and didn't happen in that case. So we're going to start with Medina v. Planned Parenthood. Then Alexa will lead a discussion on an ongoing HHS investigation of a potential religious liberty violation in the healthcare space. And then we'll wrap up with a brief summary of won't say it's not a final victory, but a good step in a case that the Alliance Defending Freedom is working on out in the Ninth Circuit. So lots to cover. Let's dive in. So Medina v. Planned Parenthood, it's a big case, but I was kind of surprised. I don't think it got quite the same media attention over the past few months during the Supreme Court term that I kind of expected it would. Yeah, with like the Newsy case, St. Isidore was big before it got resolved with a fizzle. The birthright citizenship challenge is big. Mahmoud v. Taylor. There are a lot of hot cases that have been constantly in the news headlines. And I was surprised to find like not everyone's been following or is even aware of Medina Planned Parenthood. I was talking to a family member yesterday, telling him that this case dropped, and he's very plugged into politics and law, and he hadn't heard of it. So that gave me all the more desire to cover this case in depth on the podcast. But also, if not mischaracterizations, the gross oversimplifications that come when the Supreme Court releases opinions, I think are worth some clarifying, especially one like this where the legal issues are pretty they're not particularly complicated, but there's a particular thing that's being decided. I don't think the media always gets what's happening. Yeah, I saw a post on Twitter X yesterday that alert victory, SCOTUS defunds Planned Parenthood, and I mean that's not what happened. It allowed South Carolina to defund Planned Parenthood for Medicaid purposes, so kind of. Point being, it's easy to miss what actually happened here. I think what happened here is really important. And so I want to talk about what exactly that was so we can understand, what precedent was set, what's going on here. So the factual background for those who have not been following Medina v. Planned Parenthood stems back to, ultimately to the passage of the Medicare laws. But for our purposes, in 2018, the governor of South Carolina, Governor McMaster, signed an executive order stating that Planned Parenthood is not a qualified medical provider, service provider for purposes of Medicaid, period, not for any medical services. And that is what triggered this year's long lawsuit. So to back up a little bit and understand why that matters, first of all, Medicaid does not allow dollars to fund abortions directly, right? What Medicaid does allow is for non-abortion services to be funded by Medicaid dollars, even if it's at an abortion provider like Planned Parenthood, right? So you can't use Medicaid funds to fund an abortion at Planned Parenthood, but you can get whatever other covered services Planned Parenthood offers that fall under Medicaid. So another thing to point out is the way that Medicaid works. This is probably remedial for right? But Medicaid is a federal program, so there are federal dollars, but they flow to the states and then the state administers the need-based healthcare programs. So federal dollars administered by the states with a lot of conditions, right? The federal government attaches, I think it's like 80 something conditions that the states have to abide by in order to receive and distribute these funds. So there's a lot going on there. But one thing that it does not clearly do is define for the states what is a qualified medical provider, right? And that's the main thing that was at issue here. Um, because again, so we get to this point where, okay, Planned Parenthood obviously can't get Medicaid funds for abortion, but they can theoretically get them for all the other services that they provide. Um, if they're a qualified provider as defined by Medicaid. Of course, Medicaid doesn't define that term, so it's up to the states, which I think makes sense to me because, well, for one, who else is going to do it? The federal government did not define it because it's not in the statute. But also, traditionally and typically, states are the ones who regulate health, right? Like the medical licensing boards, the regulation of medical clinics, and all of that. It's a state level decision. So for that decision, what's a qualified medical provider to be decided by the state? I don't think it's very extreme. I think it's kind of the obvious way to resolve this. So governor says Planned Parenthood is never a qualified medical service provider in South Carolina, and this sets off the case. So there are two legal issues at play here, and interestingly, this case really isn't about abortion like at all, right? I mean, it is insofar as it gives states the potential to defund Planned Parenthood from receiving Medicaid dollars, which hurts the abortion industry, especially because I think Planned Parenthood is responsible for something like 40% of the abortions that occur in America. But it's not directly about abortion. Like it's not really in the legal arguments. That's not what's going on. So the two issues at play, the way I see it, are for one, who decides what any qualified provider means for purposes of Medicaid, and two, and again, I think lost in a lot of the media. This is mostly about the second question. Does Planned Parenthood or a Medicaid recipient have a right under this Medicaid provision, some kind of a right to qualified services from Planned Parenthood that justifies them using the federal statute, Section 1983, to file basically a civil rights violation lawsuit? Now, I don't want to get too in the weeds on Section 1983, and those who have listened faithfully to this podcast know that my former co-host, Mary Margaret, loved getting into the weeds on 1983. So a quick shout out in memoriam to Mary Margaret, who loved 1983 claims, and it's kind of hard to talk about them without her. But I think, Alexa, you bring some of that same energy. So I think so I'll let you weigh in before I go into my final points, but just for very brief remedial understanding. So Section 1983 is basically, it was created in the 1860s. It's a statute that gives people the right to sue if they're basically their civil rights. It says any rights under the Constitution and laws, if those rights are violated by under color of government action. So it doesn't necessarily have to be a government that's injuring you, but it has to be, through some kind of a government action, so a law or a constitutional provision. So this was traditionally used for, after the Civil War amendments were passed and there were still race-based constitutional violations going on against Black Americans. 1983 was a way for them to actually sue, right, the local sheriff or the state actor, whoever was clearly violating their constitutional rights. That expanded a little bit. There have been other rights that have been sued under. If people are like the Fourth, Fifth, and Sixth Amendment, like criminal protections, right? If you're violated in an illegal search and seizure or something like that, you might have other police action. You might have 1983 claims. So the point is, you have to have a right. You have to have a legal right that's afforded by the Constitution or the laws of the United States to use 1983 to sue. So that was the question here. What right is being invoked by Planned Parenthood, by the Medicaid recipient, that justifies a 1983 action? So I'm going to take a breath. Alexa, do you have any thoughts thus far before we dive into the outcome of the Medina case?
Yeah, so the first thought I had while you were just discussing what you saw on Twitter and what people have been talking about is it's just really important the way that we talk about these cases, even in the media generally, like news stories or podcasts and things like this. It's important to not overstate or understate the issues that are involved because while, yeah, Planned Parenthood could be defunded in a particular state for this, and other states could now take this action, there are states that could now walk the opposite direction. So it's not that this is required for states all across the United States after the Medina case. And I think it's important that we talk about it in that way in the media so that people are not misled and mischaracterizing these cases and therefore like losing trust in the judiciary, maybe more generally.
Yeah, no, that's a great point. And I tend to like I personally tend to be not particularly spicy on Twitter or LinkedIn. I try not because it gets so nasty on there, but I do find myself actually weighing in on some of these and saying, no, actually, sorry, that's not what the Supreme Court said. Because you're right, the discourse is really important. It creates, well, it does a lot of things. I mean, it continues to heat up the already polarized political discourse, but it also puts sometimes undue fire on this on the courts, right? I know
Right.
I was at a panel last year for the Federalist Society was talking about this, that like when there's irresponsible or just ignorant media coverage of these cases, you're lead you know we've had instances of federal judges being attacked. In some case, like there was a judge in New Jersey, I think, right, a few years ago, whose spouse and child were shot by like some crazy person at the front door who was mad about a case or something. These things happen a lot, like attacks on judges. And of course, they're weighing in on important things, but when like the media is conflate or misconstruing these cases to like drum up clicks, but is inaccurate in the process, like you're bringing heat on the courts that's not even appropriate. Um,
Mhm.
anyway,
Especially when the case is titled Medina versus Planned Parenthood, which
yeah.
automatically gets more traction than maybe something else that the court's going to release this term.
Yeah. Yeah, right. And if you write something that says like Supreme Court defunds Planned Parenthood, I mean, you're going to get click and click and click, but it's not what's going on. Yeah.
Mhm.
So good point. Thanks for throwing that out. So what actually did happen in this case? I think we've kind of teed it up with the background that we just said. It was a 6-3 decision. And it does what we expected it to do. It says, the 1983 statute is you need to have a cognizable right, and that's most of what this case is about. Like what does it mean to have a right that 1983 can be used for? And so first of all, anybody interested in like the backstory, the history of Section 1983, its proper use in the civil rights realm and where it started to go wrong, should read Clarence Thomas's concurrence in Medina v. Planned Parenthood. I was just listening to the Claremont Institute's podcast the other day, and they were talking about, I think it was Skermetti and Justice Thomas's concurrence, and he's like, yeah, it's just generally a good principle that if there's a ruling from the majority, but then there's a Thomas concurrence, always read the Justice Thomas concurrence, maybe even read it first, because I mean, well, I think there are a lot of reasons for that, but I think he's a very clear writer, and I think he'll go right to the crux of an issue. So here, Justice Thomas's concurrence does a really good job of explaining like 1983 was originally pretty specifically for redress for this like civil rights violations, race-based civil rights violations based in the pre-14th Amendment Civil Rights Act in 1866. So that was pretty much what it was passed for. It was amended and expanded a little bit to include rights not found in the Constitution or that civil rights bill. But what Justice Thomas does a great job of going in detail on, but what also the majority opinion focuses on very much is that, listen, you have constitutional rights and then you have this realm of statutory rights, which is a little bit murkier, right? So constitutional rights are clear. They're usually in the Bill of Rights or in the amendments to the Constitution. It's obvious that it's a right in the American legal sense of the term. But with rights conferred by Congress, it gets murkier, right? What are we talking about? And so the analysis in Medina goes, this is pretty much what disposes of it. Is there's a line of cases, there's a particular case called Gonzaga that the Supreme Court makes a lot of mention of, a previous precedent that's basically says, listen, if, and this is in layman's terms and I'm paraphrasing, but if Congress intends to confer a right, that's not to be taken lightly. So they have to explicitly confer a right by, like saying that they're conferring a right, basically. So the Congress has to use the rights language, and the court, I'm just looking for the quote here, but the court actually gives a couple examples. They say, Congress knows this. It has created statutory rights before that would be actionable under Section 1983. For example, I'll read from the Medina opinion here. Federal Nursing Home Reform Act provisions require facilities to protect and promote residents' right to be free from restraints. And there are provisions titled transfer and discharge rights in a subsection of that act, right? So when Congress wants to create a right, it knows how to create a right because it talks about creating a right. I'm being a little bit flippant with it on purpose because the court, frankly, was a little bit snarky with how they treat this. Right? What is the clearly conferred cognizable right that's being bestowed here in the Medicaid provision when they say that, any qualified provider can get Medicaid funds? I mean, to me, the fairly obvious answer is there is no right being conferred, because if they wanted to, they would say, oh, and by the way, patients under Medicaid have the right to use any doctor they want without the government deeming them unqualified for whatever reasons, right? There's a way to have
Mhm.
done this. Congress clearly didn't do it. So that's how the story ends here. And I think it's important to realize if they don't say, like, therefore Planned Parenthood has no, right to blah, blah, blah. What happens is there's no right that justifies a 1983 claim. So Planned Parenthood and Medicaid recipients, they don't have an ability to sue under 1983 and try to force a state to give Medicaid funds to Planned Parenthood. Um, I have a couple of practical takeaways, but do you want to weigh in on any of the legal issues or the discussion here so far, Alexa?
Well, one thing I'll just add is the right has to be more defined than simply healthcare. So we think about people having a right to healthcare and a right to access to certain types of healthcare or the ability to get access to it, but the right here has to be a lot more defined. Actually, and you saw that in the examples that you gave that the court has in the case. They're not just people in a nursing home have a right to health or safety, right? They have to be more specific than that.
Yeah, no, that's a great clarification. Yeah, or else how are they enforceable? They're unlimited, right? If you have a right to
Right.
health care, you can sue under 1983 for, I don't know, if you I mean, sky's the limit. I won't even make up hypotheticals.
Yeah.
So that's right. And you're right that those nursing home act ones were very clear, like the right not to be restrained unnecessarily. Yeah, very clear. So I think one of the takeaways, though, that I do want to highlight, because on one hand, it's not a SCOTUS defunds Planned Parenthood headline, but it is a really important check on important and controversial issues being shut down in the public square by nationwide judicial fiat, right?
Mhm.
Roe v. Wade and then Planned Parenthood v. Casey, but especially Roe was like the quintessential example of this, right? By the early 70s, it was a very uncomfortable and divisive question, right? Are we going to allow abortion into our culture? Like, this was a heated question. And then the court shut it down on very spurious legal reasoning and said, no, this is not something that's up to the states. It's not up to the people. There's a constitutional right to this and it's over. And that didn't work, right? It was, for one, an evil thing for this country to have that regime for 49 years, but it was also just ineffective, right? All it did was actually raise the temperature and continue that conversation, right? So Dobbs in 2022 was a great cure to that. It's not a perfect decision, but it's an important one to say, like, no, this is not a settled question, right? And we need to, at least at the very least, make room for sane state policy to start to fix this, right? Um, I won't, yeah, I won't go further on that. But Scrimeti, the week before last, now, same thing, right? It's not a cure-all on the, like, transgender procedures for minors thing, but it at least opens the door. It's not going to let the courts shut down discussion by claiming a right, right? No, there's no equal protection right to minors getting, surgically sterilized for gender dysphoria or taking hormones because they don't know what sex they are or whatever. It's not an equal protection violation. If a sane state like Tennessee wants to pass a sane law banning this for minors, yes, right? So I think it's a similar thing here. Not the, like, 50 state blowout win, but it's saying no, if a state decides that Planned Parenthood is not a qualified medical provider, that's a state issue, and I think a good decision. Um, and we're going to let that stand. So I think, interestingly, while we advocate for things that are objectively true and good on this podcast and at Napa Legal, these are federalism questions. Like, no, we're not going to shut down the debate. We're actually going to let states make these decisions because these are still contested issues in our politics. So, any closing thoughts before we switch gears?
Now we just have to hope some states take charge.
Yeah.
Do
I
it.
I would be very surprised if we didn't see other states following suit, right? You have
Yeah,
the bold leader, but then once people say, "Oh, like one red state decided to just defund Planned Parenthood for Medicaid, and now SCOTUS says they can do that," I think there are other states with an appetite. I would stay tuned. So now let's
exactly. Yeah.
head down the road from the Supreme Court to Health and Human Services. Take it
Yeah,
away.
so on June 20th, so 7 days ago now, but probably a little bit later when you're listening to the podcast, the Department of Health and Human Services launched an investigation of a major health system in Michigan. The investigation was launched in response to some allegations that one of the providers in this healthcare system had fired a medical professional for her request for religious or conscious accommodations. So why was she requesting these? Well, likely it seems she was requesting those accommodations from certain practices of the provider, including assisting in certain sex trait modification procedures and the use of pronouns opposite to the sex assigned at birth. So these were things she opposed on religious grounds and was seeking a religious exemption for them, and then was reportedly fired from her job for that. The Office of Civil Rights within HHS is responsible, it's the office responsible for ensuring that First Amendment and statutory conscience rights of workers are protected. And so this means that healthcare professionals can exercise their religious beliefs and adhere to their conscience without discrimination or retaliation in the workplace. So if the allegations against this general provider are true, then they did violate these conscience protections and the professional was illegally fired. So that's what HHS is investigating, is whether or not that's really the case, what really did happen here. What is it that protects workers in cases like this? So what's the statutory protection here? Well, it's a series of laws called the Church Amendments. These are statutes that protect certain public officials and authorities from violating conscience rights of employees by requiring their assistance in what the laws call sterilization or abortion procedures. So, here, those sterilization procedures would be procedures like sex modification that the medical professional doesn't want to either participate in or promote in the healthcare space. These laws protect employees, meaning that they can't be discriminated against, retaliated, lose their positions, to be fired, or lose a promotion as a result of their choice to engage in the conscience protections. So not only will this investigation look into these specific facts in this situation, but HHS has also said that they're going to assess the healthcare system at large and look at their policies and see if they have any policies in place that would violate what we call the church amendments. So they're sort of taking a broader look at the healthcare system, not just this specific case, which is an example of HHS's broader mission to ensure that conscience rights are protected for medical professionals. The medical field is one of the most delicate matters of human life, and these doctors and professionals are handling a very important part of being a human person. So it's very important that state and federal agencies are protecting statutorily and constitutionally the conscience rights of these professionals. I think you see this most importantly with New York's recent decision to legalize medical aid in dying, physician assisted suicide. It just became the 13th jurisdiction in the United States to do so. And so it's sort of like now more than ever, you need to see doctors and medical professionals being protected from their choice not to engage in certain practices like that, or like abortion or sterilization procedures.
Yeah, ugh, there's a lot to say here. I think for one, I was just as a side note, but you're the medical aid in dying. I know that's how they like labeled the bill in New York, and even physician assisted suicide. I always am kind of afraid that the other side on these like life and human dignity issues does a much better job of messaging, of
Mhm.
framing what they're trying to do in a much kinder and more sympathetic and nice
Yeah.
way than is what's actually happening. So I was just thinking about that. I mean, even medical aid in dying and even physician assisted suicide, it's like I don't know. I feel like maybe we should even be more aggressive on some of these, like call it doctors helping kill their patients. I don't know. I'm just kind of
Mhm.
thinking off the top of my head, but it's so sinister to call this like medical aid. It's not medical aid. You're you're killing your patient. Anyway, that's an aside, but I think two thoughts on this exemption issue. For one, I'm glad HHS actually has this on their radar and this is being investigated because these are huge problems, and especially in huge health networks, there's a lot of turnover. It's probably easy to lose these in the shuffle where it's like somebody asks for religious exemptions, you just kind of quietly deny them, and then you find another pretext to terminate them. You wait a couple weeks or whatever, or not at all. Maybe they're being bolder sometimes. But so I'm glad that they're investigating it. I think this can be really, it can fly under the radar, right? There's so much turnover. There are so many of these kind of issues, and um, I'm glad it's getting a close look. But I think the one thing that caught my attention is the accommodations that were being sought are for very different things. They're all important, but I mean, on one hand, you have um, exemptions from like assisting in certain sex trait modification procedures, which is just horrifying. And I think that like we've talked about in past weeks on the podcast with the medical aid in dying bill in New York, that this is a huge problem for the traditional oath that doctors take, right? Like the medical aid in dying one is an easier, more obvious example, I think, because patients are dying. And even like the American Medical Association has like pretty strong ethics protections saying opposing physician assisted suicide. I think fundamentally because, the doctor's primary purpose is to heal and to do no harm. And obviously killing your patient is not healing, but is doing harm. That's like a clear example. But I think it's similar here. I mean, not only should this be accommodated in religious cases, but this stuff is very disturbing. It's one thing, obviously, to provide like a hysterectomy or a double mastectomy for cancer remediation, then you're not doing harm. Nor are you mutilating a healthy body. You're taking out, cancer, and the modifications are an unintended effect, right? Very different situation than if somebody has gender dysphoria and thinks they're a gender other than their biological sex. Again, I'm not a doctor, but I think just using reason, like that's harmful. So again, I think it's always important when we discuss these touchy issues to cover both that like religious exemptions because of sincerely held subjective beliefs are important, but there are also objective problematic things going on and we need to speak out against them. It's not just that religious people should be able to opt out of these things. These things shouldn't be done at all. So I always feel a little bit of a duty to step beyond the neutral religious liberty sphere and sometimes say these hard things. Mostly because I don't work for the Oregon school system, which we'll talk about in a minute. So I can say things like this and I won't get fired. So I feel like I have a duty to. So one more thing I'll say on this HHS case, though, is that, like I said, part of it was the asking for exemptions from these like sex trait modification procedures, but the other side was asking for exemptions from certain practices like requiring use of patient pronouns that don't align with the patient's sex. And I find this so infuriating because it's not an issue that comes up because if you're talking about, let's put aside the fact that it's not healthy for people to identify as what they're not, right? But even that aside, if you want to like, okay, we want to accommodate and respect our patients, and if the patient is a biological man who identifies as a woman, we want to refer to him as her. You don't talk to a person with third person pronouns. Like if I'm talking to you, Alexa, I don't ever use she, her. I don't call you she, I call you Alexa because I'm speaking to you, right? So this is not policing patient care. It's policing the way you talk about the patient in the third person, presumably when the patient's not generally present. Like, and if you want to avoid this altogether, there's an easy way to do it is you refer to the person by their name, right? Instead of like, okay, she or he is doing this, you can just tell the doctor, okay, Mrs. Smith is, or well, Mrs. is a problem too, I guess, but you just use the first name, right? Michelle is presenting with these symptoms. You don't have to use the pronouns at all. So I get kind of it's very disturbing when there's this imposition of you must use these pronouns. Like, why? For patient care? I'm not talking to the patient. Um, and I've experienced this in the government when I worked in government in the public sector. There's not really a situation where you have to use these pronouns practically. It's the way that English works. You can have a coherent conversation with and about a person without invoking these fantastic gender identity pronouns. So I think that one should certainly be accommodated because I really think for medical care it's a complete non-issue.
Yeah, I'd be curious to see, we don't have the policy in front of us of the healthcare provider in Michigan, but I'd be curious to see what exactly their wording is because it could be the case that they require you to use preferred pronouns and a preferred name. Some
Right.
of these people will change their names. And then, yeah, you might be stuck in the same situation where you really do need an exemption or an accommodation for using what should be their actual name, right? But if they don't have that kind of requirement, it's only with respect to pronouns, then you're right. You just have an easy workaround that
Yeah.
seems maybe very easy to accommodate and not difficult to do, and probably something you shouldn't even have to seek an accommodation for. You should just be able to do in the workplace naturally, and multiple different people should be doing this such that it's not really that big of a deal.
Yeah. No, I agree. And again, I worked in the public sector where there were transgender identifying people, and I didn't never ask for an exemption, or I just you just use the English language in a way where it's not an issue. It
Yeah.
involves some care because people are so sensitive on this, but yeah, I agree. You shouldn't even really need an exemption for this. Also, I don't want to go off too much for the purposes of time, but I think that's an interesting question on the distinction between using preferred pronouns and preferred names, because I'd be curious. You don't have to give your opinion on a hot topic if you don't want to, but I think it's an interesting one because I do think that there's a difference. I think that because names are kind of fluid. People use goofy nicknames, people change their names, people prefer to use a name that doesn't sound like a name, right? I have family members, extended family members who use nicknames that sound nothing like their name or any real name. And also there are like, right, from names like Taylor and Jordan that are used by both men and women, and that even historically ones that have changed, right? Names like Ashley and Evelyn that have been men's names in Anglo culture and are now very obviously women's names in America. So I think there's more fluidity. So I think there's less of a moral dilemma. And listen, if somebody whose birth name is Michael wants to be called Jennifer, like whatever, I think I would understand if somebody had a conscientious like problem with that too. But I think the pronoun one is more directly flying in the face of the reality of biological sex because he means boy, man, she means girl, woman, and to call a man she or a woman he is just, I think that's to me a more direct moral issue. I think the name one, there's some room for disagreement. I don't know. If you don't have any thoughts on that, feel free to not implicate yourself.
No, I love implicating myself. No, I think that you're right. I think that there is a more direct issue with the pronouns themselves. But I think also with the choice to change one's name, there is still quite a large implication, especially when it tends to be, I think, pretty obvious and purposeful. So it's not somebody, just saying, oh, well, it'd be fun if I shortened my name to this three-letter word, or, this sort of sounds gender neutral or something. But there's a real difference, I think, between like, okay, I've grown up in school my whole life and I've been Michael. And now when I go to high school, I really want to be Jennifer.
Yeah.
And telling all the teachers and the students that have been with you for all of the years, like it's a very obvious decision and purposeful one. And so I think in a case like that, I would still not feel comfortable using a different name and I would have to stick to the original name.
Yeah, that's no, that's fair. Although I do find it interesting that a lot of like, I want to use the proper terminology, people who identify as transgender as something other than their biological sex often do use like gender neutral or gender ambiguous names. I find that kind of fascinating that you would think if somebody's going all in on the I'm not a man, I'm a woman, you would want to be, right, Ashley, or but you get a lot of, and I'm not using specific examples, but I'm just thinking through I know a lot of, yeah, people who trans identify and have used Alex and Taylor and Jordan. And I just think that's interesting that if you're like,
Mhm.
if you're trying to make a statement that you wouldn't make a little more of a statement. Anyway, um, prone to tangents, as Alexa and I are often off camera and off mic as well. But we will jump back in and I think finish up with a discussion of a victory out in Oregon in the Ninth Circuit. So this one is on a similar topic. So there are two women who have been involved in this fight for a couple of years now. They're Oregon public school officials. Believe one was an assistant principal and the other is a teacher. Started a grassroots movement called I Resolve. where they advocate for the rights of parents and teachers when a student wishes to go by names or pronouns inconsistent with his or her biological sex. See, so there's a flow here to this conversation. Those tangents were intentional. Uh, but so this is important. It's the other side of the coin, right? As this LGBT ideology comes with these demands, what these two school officials did was advocate for the rights of parents and teachers who have issues here on again an unresolved topic. So these Rachel Sager and Katie Maynard are the two women involved. They launched a website with some video content explaining their beliefs about the truth of sex and gender and all of this. And the two women were both suspended and later fired from their positions. They sued the school district for unlawful treatment and discrimination. There were free speech claims, free exercise claims, and there's another, it might be an equal protection, or it might be, I think it's a due process clause. Let me make sure that I'm correct on this because I don't like to throw out the wrong claim. Free speech and religious freedom looks like they were the main claims. I do believe that there was a due process claim in there, but I won't delay it here. So anyway, they were fired. They sued. The district court out there ruled against them. And the Ninth Circuit recently heard the appeal and vacated that decision and sent the case back to the district court for a proper hearing on the merits of this. So don't want to go into too much depth for the purposes of time and because it's still an unfolding case that's going to go back to the trial court. But the Ninth Circuit's opinion was pretty clear that the school district's interests in whatever do not outweigh plaintiffs' free speech and free exercise rights. And there's a good quote from the court, a government interest does not provide justification to silence discussion, quote, simply because superiors disagree with the content of employees' speech. And that's the whole crux of this case. To me, I think it's worth pointing out these are public school employees, which means they are employees of the state, which means they are directly implicated and by the First Amendment, right? These are the schools, their employers are state actors. So of course, there are reasonable regulations on speech, on the exercise of religion, right? You're not going to conduct a prayer service during class time in a public school, although even that's questionable whether that's unlawful. But I mean, right, there are certain things you don't say. We're not going to talk about like explicit things. We're not going to get into like fiery, in-depth, above the grade level discussions of certain hot political issues or moral issues or whatever. Yeah, there are certain time and place regulations, but public employees don't forfeit their constitutional rights because they work for public schools in this case. So I think it's really troubling to see educators at a public school fired for engaging in exactly the type of political and religious speech that's most protected by the First Amendment, right? Controversial, unsettled political and religious issues are exactly what the First Amendment was meant to protect discourse on. But I think also you couple that with how unevenly this kind of treatment occurs, right? Like it's not like it would be one thing if it was content neutral and the public schools say, listen, we don't want our teachers weighing in on the LGBT stuff, on the pronoun stuff, none of it. We don't want any of it because it's upsetting parents, it's upsetting students, it's ruining the educational environment of our school. You'd still probably have a First Amendment question of whether you can stop political speech from your teachers. But at least keeping that out of the classroom, maybe. But then when you see, and you don't have to look far, I'm obviously not highlighting one anecdote. You can do a quick Google search and you will find all kinds of teachers boldly proclaiming Pride Month and their LGBTQ status and telling the kids about all kinds of things with what pronouns they can be and what genders they can choose. This is rampant in the schools, and sometimes it's right in the school policies that teachers and guidance counselors are allowed to talk to kids about this. So to see two school teachers just take the other side of an ongoing political issue where one side is clearly allowed to be discussed pretty freely in the schools, but the other side, if you touch it, if you start an organization pushing back on the agenda of one side, you're just fired. Thank God that people stand up and actually say something here. So I just want to say before I open it up to you, Alexa, I'm always grateful to see people leading the charge, especially these two women, because they probably knew what they were getting into. They're at a public school in Oregon, not exactly a bastion of like free speech and openness for right of center folks or religious folks. So they probably knew that there was a fight coming, and it's really important. You need bold people to lead the charge for faith and for sanity and for public discussion of these issues, but someone needs to go first, right? It's like there are probably a lot of teachers who would like to say something against the ruling regime about these kind of LGBT pronoun issues, but it's scary because you have a livelihood and you have mouths to feed and you have a paycheck you need to bring in, and you don't really want to be the test case to see, well, am I going to get instantly fired for this? Am I going to be sued? Am I going to jail? Right? Somebody has to do it, and these two women did it. So hats off to them. We're really grateful for them leading the charge here, and also have to shout out the Alliance Defending Freedom for taking this case, especially Attorney Matthew Hoffman, who argued this case. He's currently one of our Good Counselor Project fellows at Napa Legal this year, and an attorney at ADF. So thank you to Matthew and for ADF for taking and arguing this case. And now, as it goes back down to the trial court, we'll hope for a better outcome the second time around.
Yeah, I think this is a great example of how issues like this really trickle down into larger parts of our culture. So you see this actually in the HHS context too, right? Like if they can just fire healthcare professionals for failing to adhere to their policies, then this is what's taught in medical school. And this is what other providers in other states will do. And if these women can just be fired for deciding that they don't agree with general policies at the school district, then this will happen in other school districts and it will happen in other schools in the school district. So you see a real effect to what happens in the resolution of these cases beyond even just the two people that are parties to the case or the two people that are involved in the case more directly. I think it's also important to note that this could be an example of what we call chilled speech. So this is what you were describing, you know, when you're thanking these women for standing up and being involved in this because they might decide the stakes are just too high and I can't really afford to do this. And then they're not only afraid to fight for it, but they're also then afraid to speak about it, which is what we might call chilled speech. So when you have a fear of legal repercussion, from whatever speech you're engaging in, which typically means that it's contrary to the status quo or that, you know, where you are, people just generally don't agree with it or the policy is against it. And you decide not then to engage in your free speech right to, you know, speak out against this, develop a website, do something about it. Even if the speech itself that you wanted to engage in would be perfectly legal. So you wouldn't be doing anything quote unquote wrong in doing that, and that's important to remember that, like, that right still exists even when people feel like they can't necessarily engage in it.
Yeah. No, that's a great way to wrap this up. And I think I would just give one, because I know that a lot of the people who listen to this podcast work in um friendly organizations, right? Christian or conservative organizations where they have a little more leeway. And I think it's important maybe I'll conclude with this. I spoke with a couple of my colleagues to a young Catholic professionals panel last year, and we were talking about the virtue of courage, and particularly the virtue of courage in the professional life. And one of the things that it always sticks with me, it's from a piece I think I read at the Claremont Institute a couple of years ago, but how with this climate of chilled speech on these issues, right? It's very frustrating because um, you get the sense that on a lot of these issues, there's a majority of ordinary Americans who actually are not okay with the ideological stuff going on, especially on the trans issue. But they're afraid, and it can be frustrating. Like, if so many people are against us, why don't they speak up? And what this article was saying rightly is that give them some grace. Like, these people are they're school teachers or they're nurses or they're factory workers where, like, one wrong statement that offends the boss and they're gone, right? They have kids, their livelihood is gone. This is very scary. So when people like Rachel Sager and Katie Medder, right, stand up, even though they could very well lose their livelihoods, that's real courage. Versus, like, I've spoken boldly on like every conceivable cultural and political and religious topic out there, like on record, but it's not particularly courageous because I work for the Napa Legal Institute where, like, we talk about these issues and I'm encouraged to do so. So I'm fairly cancel proof, or at least cancel resistant, right? Like, I can't, no matter how much outcry there is, my bosses are not gonna fire me for saying something controversial on these important issues, because that's part of what we do, particularly in the religious liberty sphere, of course. But so the point being is, for one, when somebody who does have a lot at stake says something like this, takes a stand. It's a lot more courageous than if I do it. But for two, those of us who are not easily cancelable, who work for organizations that are friendly on these issues, I think we have more of a duty to actually speak out and be those people who kind of lead the charge in bringing these issues to the public square, because we're in a much better place to do so. So, yeah, the chilled speech issue is a really important one. If we're going to kind of defrost that speech, I think people who are in a better position to do so really should lead the charge. But again, God bless these two women for having a lot at stake and going full speed ahead anyway. Um, all right, any parting thoughts?
Thanks for having me.
Yeah, thank you for being on. Hopefully we'll get you on again before the end of the summer. All right. So with that, thank you all for joining us for this episode of the Napa Legal Podcast. If you enjoyed the content we're putting out, as always, we'd appreciate if you would like the podcast, subscribe to the channel on YouTube, Spotify, or wherever you have found us. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. And in particular, I would be very surprised if there was not another big Supreme Court case that will be on our schedule for next week. So stay tuned. We'll talk to you next week. Thanks for joining us, and God bless you all.